No. There we go. I see something. Okay. All right, Mr. Trudell, you rejoin us.
Hello, yes. Good to
Good
see
morning,
you.
sir. How are you today?
Good, thank you.
Good. I hope you are enjoying a pleasant fall. All right. Are you ready to go?
All set.
Okay. Good morning. Court's in order. Our court is assembled. We started at 10 o'clock. It's a minute or two after that now. This is time and date that the court set for a status conference. I appreciate everyone who is here in person. I welcome everyone who is attending online, and to any members of the public. Welcome to the Michigan Court of Claims. It's our privilege to serve all the people of the state of Michigan in this court, both individually and collectively. It's a high honor for all of our judges and for myself and for our staff to be able to participate in these cases. Let's have appearances, starting with the plaintiff side, the lawyers who are present in the courtroom. And I'm going to take
Tom Juan, Mass Plaintiff.
David Dubin here for the class plaintiffs.
Jason Thompson on behalf of the class.
Elizabeth Fagan on behalf of class. Pauline Kennedy on behalf of.
Right. Is anyone online going to participate on behalf of the plaintiffs? All right, no one so indicating. Moving to the other side of the V in the case for the defense.
Morning, Your Honor. Nathan Gamble here on behalf of the defendants.
And good morning, Your Honor. Richard Cole on behalf of the defendants.
And Nathan Frischkorn on behalf of the defendants.
How do you spell your last name, sir?
Frischkorn.
All right, Mr. Fishkorn, I don't think I've seen you in this case before. Welcome.
Thank you.
You joined this happy group of litigators. We look forward to your assistance in proceeding in the case. Thank you. All right, as I indicated, this is the time and date that's been set for the status conference in the case. I think in many things in life, perspective is important. So I want to say a couple of things to help us keep our perspective. This case originates from events which took place on May 19th, 2020. That was 1,997 days ago. The plaintiff's first complaint was filed on May 27th, 2020. That was 1,989 days ago. On August 3rd, 2020, the motion for summary disposition was first filed by the defense in this case. That was 1,921 days ago. On September 7th, 2023, the Court of Appeals issued an opinion denying summary disposition to the plaintiffs or to the defense in this case. That was 791 days ago. On December 21st, 2023, the Supreme Court dissolved the stay that they had issued and denied application for leave to appeal 686 days ago. On January 31st, 2024, it was my privilege to receive an order from the Chief Judge of the Court of Claims assigning this case to me. That was 645 days ago. On January 12th, 2026, that is 67 days from now. So there has been a whole lot more time and a whole lot more minutes on the clock leading up to today than we have until the end. I say that, and I bring these things to everyone's attention. And the final note is that on January 12th, 2026, when we begin this trial, it will be 2,060 days after the events giving rise to this litigation took place. The court has had the privilege of meeting with all of the attorneys except for Mr. Frischkorn many times before. And I am grateful that the parties are so capable, that the litigants are so capably represented by both for all the plaintiffs as well as the defense. I've issued a lot of scheduling orders, issued a lot of opinions and orders. I understand there is an application for leave to appeal the most recent denial of summary disposition. I think I said it on the record, Mr. Gamble previously, but to the extent if there's any confusion whether or not I granted a stay, I don't grant a stay. So I think probably everybody understands that. And I know that the matter is before a court superior to me, and they'll make a determination whether leave is granted and whether a stay is entered. And that tribunal is made up of 21 judicial officers who are authorized to serve on it because 4 of us are Court of Claims judges, so we can't serve on the Court of Appeals cases. I'm sure whatever the motion docket panel is that receives it and the commissioners of our Court of Appeals that review it will give it full and fair consideration, and they'll let all of us know when they will let all of us know. If the application is granted, if there's a stay, then that speaks for itself. Then this trial court will be divested of the authority to act in most capacities. Certainly will be able to potentially have some type of meeting. But I whenever I'm on the motion panel or a reviewing panel and the trial court keeps doing stuff after we've granted leave, it never leaves me super happy. So I don't want to. My guess is that if the application's granted and a stay is issued, that the trial it would be very unlikely it would go forward on the 2060th day since the events took place. But we'll find out at the same time, I suspect. One thing interesting, just as an aside, some of the Court of Claims judges, several of us have had applications for leave to appeal by both plaintiffs and defendants in various cases. This, it's obviously it happens, but we don't get notice. And it's the funniest thing because as a circuit judge, you always got notice when something happened. But apparently we're going to be working on, how do we make sure that we at least know something's happening at any rate? That's where it is. Prior to today and today, had the chance to review the agenda items. I've reviewed all of them. What we're going to do, what I would propose is to take them in the order in which they were received. Just make sure I've got it. All right. Okay. And it All right. So the plaintiffs submitted proposed agenda items on October 23rd. It's somewhere around 2 o'clock. Defendants submitted proposed agenda items on October 23rd. Near as I can tell, somewhere around 4 o'clock, which means it looks to me like the plaintiffs filed first. So my intention would be just to start with their proposed agenda items. And then I know there's a rebuttal one, or I'll just call it a rebuttal one, another agenda item pleading by the plaintiffs that I had in my hands downstairs, and for the life of me, of course, I cannot find it. Yep, now I found it. On October 30th, 2025. So that's sort of how I would envision us moving forward, at least for the start today. Any objection from plaintiffs starting out with that process? Mr. Campbell, defense?
No.
Okay, fine. Plaintiffs, you may proceed. Mr. Trudell, can you hear Ms. Almanroad okay from council table?
Can she try speaking?
Okay, why don't you, and maybe even just hold the microphone in your hand. Can hearken your inner rock star, Ms. Almanroad.
Hi, can you hear me now?
Yeah, I can hear now.
Perfect. I'm good with all council doing that until I ask somebody to go to the podium. But we just do need to pass around like we're at a meeting of some sorts. We're in an open meeting, so. And frankly, for interested individuals who are watching online, it'll be better for them so that they can hear what our very capable lawyers have to say. So Almanroad, please proceed.
I can't hear. Your Honor, I can't hear her.
Yep,
Okay.
let's
No.
see.
Now can you hear me?
Yeah, I can hear you now.
Okay, the first item is the court's amended notice and pretrial order, paragraph 1, which reads: the final pretrial Zoom conference shall be held on Monday, January 5, 2026 at 10 a.m. The trial attorneys and persons with settlement authority must be on the conference. We're seeking some clarification of that. Is that a settlement conference, or what is the format of this?
Well, I can't conduct a settlement conference, obviously, since I'm the trier of fact. So it's not a formal settlement conference, but I will make inquiries. Hey, is there any chance that this thing is going to get resolved? The likelihood, obviously, what I would expect, the answer will be no, we've tried, Your Honor, we're going to trial. So that would be the nature of the settlement piece of it. As far as what the court hopes to accomplish is that, as I said, it'll be 2,060 days on January 12th. And I'd like to make sure that in the 7 days between the last pretrial conference and the 2060th day since these events happen, I don't want to have 14 motions in limine and emergency whatevers. That's because that I'm trying to make sure that everybody is ready to go.
Understood. I have one more question in regards to that our team does. The trial attorneys, persons with settlement authority would be the clients, but we have over, approximately 2,000 clients, and no one would be able to fit in the class. No one would be able to speak on behalf of all the others. The same issue that we encountered when we were before Judge Murray for the settlement conference. And we're asking how the court envisions us having our clients present for this.
I envision you having the authority to resolve this case. And what mechanism you choose to facilitate that is your responsibility, counsel. If that means that you have contact that you have a high-low or something along those lines? I mean, I, what do you think we should be doing, Ms. Alman Road?
What we usually do in these circumstances is we conditionally enter into a settlement and that we will recommend to our clients. And then we go back and get the client's approval to participate.
Right, okay. And then here's the rub of it. You'll have less than 72 hours to get the approval of them all, because I'm not adjourning this trial. If you actually reach a settlement, which I don't think is going to happen, but if you do, we're not waiting 90 days. You're getting, and so you need to have in place a mechanism by which, if there is somehow a resolution of this case, that you are able to bind the clients and the parties before January 12th, 2026.
Your Honor, we will discuss it among ourselves and come up with a plan.
Outstanding. Good. Okay.
The second issue on our agenda is the trial format. Starting with opening statements, is the court expecting opening statements?
I am going to allow opening statements. I'm not at all sure that they're necessary, given the many opportunities to be together that the court has had with all of the lawyers and all the motion practice. If a side chooses to make an opening statement, my recommendation is that it be 30 minutes or less. My direction is it may not exceed 60 minutes. So if someone is giving an opening statement and they are at 55, they will be getting, they may, if I remember to, get a notice that says you got 5 minutes left, counsel. So my expectation is opening statements. Well, not my expectation. I am ordering and will memorialize this after this case, that the court recommends that opening statements, if undertaken by the parties, be limited to 30 minutes. However, counsel will be allowed 60 minutes in its entirety. That answer the
Yes, it
question?
does. Thank you, Your Honor. Our next item under the trial format is, will the parties be permitted to present witnesses using internet-based technology, such as Zoom?
right. Any expert witness must be present in court for the entirety of their testimony. I will not take the testimony unless it's a Debene essay that's already been done. If you all do Debene essays, obviously I'm not going to be there for that. That becomes, it'll be less ineffective in a bench trial than it is ineffective before a petite jury. However, if a witness is an expert and is offering opinions, I find it hard to fathom, with the magnitude of the import of the defense for the defendants and the plaintiff's claims for the plaintiffs, that these individuals would not be here in court. And again, I go back to what I talked about initially, perspective. Is it hard to get experts in person? Yes. However, what is being claimed here? An inverse taking of thousands of individuals' property, which I think, I don't know this, but I think the plaintiffs are claiming the damages are certainly in excess of $100 million. Eventually, if we get to a liability, a damages stage, and potentially approaching $1 billion. So if I were the plaintiff's lawyers, I would be making sure I have my experts here in court and as many of my witnesses as I could. If I were similarly the defense, and I'm defending the state of Michigan, seeking to not be required to pay between 100 million and $1 billion. And I'm just, so if the Court of Appeals has to review this part of what I'm talking about, I'm not saying that's what I think the damages are. I have made no conclusions. There's been no evidence on proofs. I am just spitballing, and it could be zero. I bet it's more than zero, or we wouldn't have so many plaintiffs' lawyers. It could be, less than $100,000 altogether. My guess is that's probably not it. But the point of it, I'm using the numbers to my dear friends on the Court of Appeals and the 7 wonderful justices of our Supreme Court, not because I have prejudged anything, but just by way of example, the magnitude and importance for the perspective. So as far as other witnesses, I'm willing to listen to what the parties want to do. But as far as experts need to be here.
Do we need, well, it's our preference to have our experts here too.
Well,
Your Honor.
I don't, this is not a preference. They don't get to
Yeah.
testify if they're not here.
I understand.
Okay, good.
But yeah, when we ask for that, I want to make it clear that we were intending and hoping that all of our experts would be present.
Sure.
And-
Now we know they all will be, or they won't be testifying. So
Exactly, and we thank you for that guidance. But people that are not experts, such as, let's say Lee Mueller, the former owner of the dam, can he be presented remotely if we were to call him?
Your Honor, if I may,
yes,
our option, if he doesn't live here and we can't compel him to be here by subpoena, then our option is either to take a DeBene essay deposition and present it to the court, or have him appear live by Zoom or by electronic means. And so our preference would be to have him by electronic means so that you can ask questions if you want. But those are our 2 options with somebody like that, who's a witness who we cannot compel to be here by subpoena.
Mr. Gamble, what's your position on that?
Your Honor, this is Nathan Gamble on behalf of the defendants. Our preference is definitely to have people come in person. But I mean, this is such a high profile, high potential liability case. I just don't envision a situation where we have someone like Mr. Mueller who would be testifying for days. Potentially.
I am having trouble getting my brain around that witness not being live. And do I have the authority to require him to be here live?
I haven't researched that, Your Honor. I think that certainly there are ways to serve subpoenas out of state.
You can serve a subpoena, but
Right. We don't, as far as I know, Judge, we and you don't have the legal authority to compel somebody who lives out of state to appear here. There's no subpoena power that allows that. And under the court rules, a DeBene essay deposition for somebody who cannot be compelled by subpoena to come into court then becomes part of the record. I don't think the court can disallow that. And so what I was just suggesting, Judge, is that we may only have 2 choices. One would be to have it by DeBene essay deposition and submit it, or allow it by electronic means. And that's the only reason we bring it up that way.
Mr. Gamble,
I mean, the way Mr. Wan puts it, I mean, it's up to them if they want to do a DeBene essay deposition, but we still strongly feel that if a witness is going to be testifying in court, they should be here in person. And we certainly plan to have our witnesses here in person. It will include some travel. And so it's just how these should be working.
And that would be our preference too, Your Honor. But if we cannot make him come here
I
and you have those 2
understand.
okay.
I understand. My preference is that the witnesses come in, testify in front of everybody. I think it's it's much more efficient. It almost always is shorter. It's almost always more precise. I can't remember a case that I've tried as a litigator where something didn't happen, whether it was the facial expression of the witness, the slight hesitation that would have been so difficult to perceive over a video link, or more difficult to perceive, that I can think of any number of cases that those indicators that were only able to be observed because we're all in the same place impacted how I continued my cross or my direct. And in some cases may very well have made the difference in the verdict. And I agree. I know all the lawyers want the witnesses here. I also know that I serve on a court that is a creature of statute and some constitutional aspects to it as well, of course. And that the court rules for civil litigation are what the court rules are. And we may not be able to compel them to be here. So it'll be up to the parties to sort out how to present it. Just, okay.
Judge, in terms of direction from you, though, if you rule now and say he's not appearing by video, we have to, that gives us direction on whether we want to get the Benny essay deposition. But if you say,
I'm not directing that, but
when I say directing around, I'm saying, is there an order saying I'm not going to have him?
I am not
appear?
issuing an order. There will not, at this point, I do not envision issuing an order other than as relates to expert witnesses that says you may not testify remotely. I think it would be inappropriate for me to do so. I'd be happy to, Mr. Gamble, what are your thoughts, or Mr. Cole? Cool.
Your Honor, I think it would be helpful if the court provides more direction on where the line should be drawn on whether someone can appear remotely or not. If there's some
What do you recommend? What do you recommend?
if there's an extraordinary circumstance of some kind, perhaps someone's physical condition is such that they can't safely travel because of their age or illness, something of that nature. But
Okay.
I don't-
But what about the universe of witnesses who I don't have the authority to require to be physically present? That's the ones I'm concerned about.
that could potentially be somewhere to draw the line, yes. But I do think some guidance from the court so that there's just not, if it's more convenient for us,
Yeah, no.
we'll have people online.
Okay, hold on just a second. Elizabeth, could you come up here a moment, please? Pardon me, counsel. All right. Thank you for that, both Mr. Wan and Mr. Gamble. In the order that the court will issue following this conference, I will attempt to give some granularity to what the court's position is, and what the court's expectations are. I think it would certainly be helpful to have the former owner of the apparatus that is so significantly involved in this case present, but if I don't have the authority to require him to be here, I don't have the authority. So,
We'd like him here too, Your Honor.
right. Okay. Ms. Almer. Anything else?
Not an issue, no.
For records custodians for authentication purposes, are you going to require them to appear here?
That's a good question. And that dovetails into exhibits and things like that. So keep that thought. If I don't address it before when it looks like we're wrapping up, please bring it back to my attention.
This isn't on our agenda, but it's a logistical question that my team has asked me to ask. You had mentioned that we might get a conference room someplace in the building.
Right, right. What I'd like somebody, whoever your quarterback of logistics is going to be for the case, to contact Ms. Tomet, my assistant. Mr. Gamble, do you have any, is it necessary, other than copying you on an email, that they're going to have a talk? I mean, do you need to be involved with logistical stuff where we try to find a place for them to have a litigation headquarters in the building.
No, Your Honor, we'd like to be copied on written communications, but we don't need to talk about the plaintiff's conference room. That's
Okay. And I'm assuming, we all know what happens when one assumes. My expectation is, because the Department of Attorney General has an office in this building, that's going to be your headquarters for the case.
Yes, that's correct, Your Honor.
Okay.
Yeah, the only kind of logistical thing that we'll need is a second table if possible on the
Okay,
defendant's side.
yes, yeah, I'm glad you mentioned that, because I expected that we would need a second table for the defense, and I expected that we would have at least one more, and I think we have two more tables like the ones Ms. Ullman Road and Mr. Juan are sitting at, that they would be in position where attorneys Fagan and Kennedy are now, that we'd have a second row of plaintiffs' tables, counsel tables, and that we would probably just we'd single stack yours. I don't think we need to do stadium seating for the Attorney General's office, but if you say you bring in more and after today, maybe you will, but and then we would make the seating for whoever wishes to attend would be, I don't know how we're going to coordinate off, but we'll, the public will preferably not be sitting at plaintiffs' secondary tables there. It'll be for the lawyers and the lawyers' staff. Will those 4 tabletops be enough on the plaintiff side?
But I think so, with our hot seat. Yeah, I think so.
Yes,
Yes, sir.
and 2 should be enough for you all.
Yes, I think 2 is plenty for us.
Okay, great.
Thank you.
Okay, good. What else, ma'am?
In line with setting up the courtroom, is the witness going to sit at a table in the same way that they did at the Dauber hearing?
Yeah, yes, it'll be essentially like it was at the Daubert hearing would be my expectation.
Thank you. We have nothing further on our agenda.
Okay. Mr. Thompson.
Your Honor, Jason Thompson for the class. What's the court's expectation, if any, as to how large the public audience may be for the trial?
I have no idea. Dude,
Have you had any experience with having the room at capacity or limiting the amount of people?
I just think when I had the presidential primary cases 2 years ago, the courtrooms got pretty crowded. I don't recall we were ever at capacity. Dan, what's your?
I think we have 53 seats.
Mhm.
Yeah, and once we exceed that, then we start running up against the fire department staff.
Yeah, I will, as a circuit judge, I had any number of cases that had some level of notoriety to them. And the way we did it on my docket was, basically first come, first serve. And then when the seats were filled, then you couldn't come in until someone left. I suspect this is going to be live streamed. So the right to a public trial will be both actual in court, in open air quotes. Again, my Court of Appeals friends, I'm saying open because the litigators, the court staff, the court will be here present, and then anyone who wishes to be here up until there are no more seats to safely allow, will be here, and then the rest can be live streamed. We can look into, whether we want to set up monitors. If there's, and I will say in a couple of, in a traditional circuit court, large urban area courtroom, you're going to have multiple other courtrooms that you can live stream it into the other courtrooms. we just have this one courtroom. It's a big courtroom, but it's not, you know, a giant courtroom. The point of bringing that out is, you know, we just live stream it. We have televisions, monitors or whatever in the other courtrooms that people can come and go. Let me think about that, but my guess is that it's going to be, and if all the lawyers agree that, you know, Judge, let's, once the courtroom's filled up, you know, at the next recess, the courtroom should clear and then people who are waiting should be able to come in. You know, I just don't know how many people are going to want to be here. I do know with the technology that's available today, a lot of people like to just watch stuff on their iPhone or you know, whatever, Android or whatever. So I don't know. Do you have any sense of it from the plaintiff or defense side? How many?
Again, Jason Thompson for the class. I do not. It's just as we start to think through the logistics, it occurred to me that you have the press, you have the client base,
Right.
you have just curious people.
Interestingly, the press in the Court of Claims cases, because we live stream, the press isn't coming to the hearings as much. They're reported. In this case, I've read many times the next day in Gongware or MLive about things that I said, and it's like, oh golly, did I really say that? And it's because, and I was told somewhere along the way that no, they find out when the hearing is and they watch it from their desk, which makes all the sense in the world.
Yeah, I think that will be predominantly how people are going to access the trial.
Yeah, but we of course want to, I mean, anybody, any member of the public is welcome. It's an open court. So I'll let me put that in my list of things to talk to Miss Ruth about. Dan, when you've had the other trials, have you been at capacity in any of them?
Yeah, the sure trial, or it wasn't a trial, I'm sure here.
Okay, how did you deal with that?
It was first come, first served, and when a vacancy became available, we let someone else in, but we had others knowing around.
Okay. Okay. In Judge Yates's trial in July, did you get the capacity on any of that? Okay. Believe it or not, this is the biggest as far as number of seats. I think it's the biggest courtroom we have. The Lansing one might be bigger, number of seats wise, but at any rate. Okay, good things to think about. Thank you. Anything else from plaintiffs before we go over to defense?
Nothing further, Your Honor.
All right. Mr. Gamble.
Thank you, Your Honor. Nathan Gamble for the defendants. The number 3 item on our agenda regards the joint exhibit book. So the
Yes.
court's pretrial order originally required the parties to create a joint book, and we've discussed this amongst ourselves. We think that might actually complicate rather than simplify. And so the proposal that defendants have is to simply have each party create their own exhibit book. I think one way to keep it clear about whose exhibits are in front of the court at any given time is that the plaintiff's binders would all be blue, the defendant's binders would all be white. But we're anticipating just dozens of binders. I mean, it's just going to be a lot. And so I think it'll be easier. And as far as I know, the plaintiffs agree to just have each side prepare their own exhibit books. So that's all. We were just looking for the court's guidance on that.
Okay. Plaintiffs want to chime in?
We have no objection.
Okay. I want, and again, perspective, sort of the theme for today. When I issued that order, I think you should understand what I anticipated that was going to require of the defense and of the plaintiffs. What I anticipated that would require is probably 2 lawyers for sure for the plaintiffs and maybe 2 for the defense, together with a paralegal or an administrative assistant, meeting probably 6 hours a day for between 2 and 4 weeks before trial. That's how hard I anticipated it was going to be ready on the 2060th day after the events which gave rise to this case. Very difficult assignment by me. Very hard. Very specifically articulated by me, because not only will it make the court's fulfillment of its statutory and constitutional duties to adjudicate this case substantially more straightforward, it will force, and I don't mean that in a bad or a physical way, but it will require the litigants in the 67 days remaining between now and the trial to know what order the witnesses are going to be, what witness is going to talk about what exhibit. You will have to agree in the 2060 days in preparation for this trial. It is almost beyond my ability to comprehend that the parties do not know exactly what documents they're going to rely on, what documents their opposing counsel are going to rely on, what witnesses are going to be talking about them, how they are going to be offered, and who are they are going to be authenticated by if necessary. If we forego that which I have, this very difficult burden I have imposed on the litigants, that I fully, completely, and conscientiously recognize and accept the responsibility for, we do not have any pre-admitted exhibits. We do not have an anticipated understanding of who the witnesses are. And that will make the presentation of the proofs and on behalf of the plaintiff's claims and in support of the defenses of the defendants very disjointed, and difficult to follow. We have already tried one hearing, just one hearing, with multiple exhibit books from the parties. That was anything but easy for the court. All of those who were present in the courtroom, well, you may not remember, but I have a vivid memory of a two-stacked rolling library cart next to me that literally maybe if I had to go back and forth between exhibits 5 times, it was probably closer to 50. I didn't know where people were going. I followed it, but it was not a logical, systematic, and orderly presentation of the exam of the witness. If we do that, as the parties have requested, that is what January and February of 2026 are going to be like. And I am not willing to do that. I'm not willing to do that to the defending state parties, and I'm not willing to do that to the prosecuting plaintiffs' parties. I know from 40 years of experience as a litigator, the most logical way, in my mind, to present a complex case. I've presided over them. I've tried them. I've prepped them for trial and had them settle on the day of trial. And I understand the request. I understand the desire. I understand completely. It would make the preparation for trial substantially less burdensome to the plaintiffs and the defendants. It will not, however, advance the interests of justice, in my estimation. We have thousands of plaintiffs who have been waiting, it will have been waiting 2,060 days for this court to reach its conclusions. We have agents of the state who have said for 2,060 days, we didn't do anything wrong. We want the court to vindicate us. I cannot do that efficiently, effectively, and in an orderly fashion with two complete separate sets of books. The manner in which that order requires the parties is not for the benefit in the first instance of the parties. It is for the benefit of the court. I have to make a decision in this case in the liability phase, which will be one of the most important decisions I've ever had to make as a judicial officer. I need the help of the lawyers to do it. I know it's hard. I know it's tough. But I also know that which I have ordered is the mechanism through which we will have a much more orderly presentation of the proofs in this case. So that's how I'm feeling about it. Mr. Gamble?
Your Honor, I didn't want to interrupt you, but we're not asking to be excused from the process that you just described. I think I didn't communicate the request.
What are
clear.
we asking then?
I understood the pretrial order to, I'm literally talking about allowing us to send different exhibit books to the printers on our own rather than doing it ourselves. I'm not asking that
Here's-
we
Mr.
not
Gamble.
meet together. We fully intend to do that. That's the next item on the agenda, is to try and make that process more smoothly. I'm not asking to not go through each of the exhibits the plaintiffs have and the defendants have and discuss which ones we can stipulate to and not. That's not what we're asking to do, Your Honor. We're on the same page in that respect. And so that's not what we're asking. It's just that we think it'll be easier to go through that process and then ultimately print our own exhibits, essentially. I mean, it's just a very,
Okay. All right. What is the plaintiff's position?
Your Honor, Jason Thompson for the class. The defense counsel hasn't acknowledged, I think, one of the inherent problems that the court has identified, and that is whether we're going to have duplicate copies of the same exhibits. That's another problem. So if we send them to the printers separately and we haven't, called them,
Your Honor, if I may, that's not a problem, because we're going to be meeting and make sure that doesn't happen. We have no interest in complicating this. We're trying to simplify. And so that really brings us, perhaps, it sounds like this is where the court's heading anyway, which is item number 4 in the agenda, which is we have really struggled to get exhibit lists from the plaintiffs. And so right now, there's no court order in place requiring them to tell us at any particular time what exhibits and witnesses they're going to be relying on, because the pretrial order doesn't require those till December 12th. So.
Well, I sort of thought the order that said you gotta meet, you gotta say who's coming, who's gonna be at the party, what song are you gonna dance to, and how long are you gonna be waltzing? I thought that kind of, covered everything.
Me too, Your Honor. But that's why we're here. And that's why we put the item on the agenda, is we're asking the court to please order the plaintiffs to provide this information so we can start the process. We had asked for it for tomorrow and they were unable to do that. Now they've said they can do it on November 14th, but I am not confident, frankly. And we're not casting aspersions, but it's just the way this case is
No,
proceeding.
I
for 2
know,
years.
and that's my friend, all of my friends here. We have been on this journey together for 22 months together, and you had outstanding other judges on this case beforehand. And it just, oh my golly, it just is. We just need to try the lawsuit in a way that everyone walks away without having, you know, a, doing their best they can, presenting the case the best they can. But okay, so I understand. Let me have a minute. All right. I'm just, and you guys you've got to be so sick of hearing me talk. I can't even imagine. I'm sorry for that. But I'm going in the Wayback Machine of the 12 years I was on the circuit court. In the 28 years I was a Navy judge advocate. In the 8 years I was a federal prosecutor in DOJ. And I can't, in my time in private practice at a big firm,
Your Honor,
no, stop. I'm not asking for any help right now. I'm trying to articulate what I'm thinking. And it is that, Mr. Gamble, if we pursue it in the model you're suggesting, there it's multiple copies. I mean, why is it unreasonable for the court to expect, with the capable lawyers and the number of lawyers involved in this litigation, to be able to be presented, 20 exhibit books, however many exhibit books it is, and starting with, here's exhibit 1, and the last exhibit is exhibit 372 or 2000 or whatever, but that it's going forward in order of where the witnesses are, as opposed to what I experienced when we were together on the Daubert hearing, where I was pulling binder after binder after binder, and it just, yeah, I'm 65 years old and I'm not as strong as I was when I was still in the Navy, but I can still lift a binder. But I mean, it's like, hold on. It's so, it's just, and even, but I'm not a super digital person. I get that. If some of my other colleagues are very good at digital technology, they just hit a keystroke, fine. But help me out. Why am I unreasonable in this?
You're not, Your Honor. And I really feel like I've communicated poorly, because you're not saying things that are contrary to what we want. We've tried to start this process. What we are asking the court to do is to order the plaintiffs
Believe
to
me,
meet
you're going to
deadlines.
get all sorts of
Understand. I mean,
orders.
so we've been trying to start the process you've been describing, and it has been unsuccessful.
Okay.
And so we're trying to get the court's help.
Okay.
You're,
Yes.
on October 23, we had our bi-weekly meeting, Mr. Dubin and I, Mr. Gamble, and Mr. Paul, Ms. Yocum,
Okay.
and the gentleman at the end that I sorry don't remember his name. And at that time, we discussed the fact that we
Is the
agreed,
microphone turned on? Because I'm having a little
put it
trouble.
closer to your mouth.
at that time, we indicated that we agreed that we needed to start exchanging things. He wanted it like a week later or something like that, and we just simply weren't able to do it. He had filed an appellate brief in the meantime, and we had other things that we're dealing with. But we told him we would do it by November 14th, that we would start exchanging, that we had contemplated that we would start exchanging, because that was the only way that we'd be able to get this done as a joint effort by December 12th. And so it's absolutely incorrect that we did not agree to produce.
All right. Thank you.
Your Honor, if I may, when
No.
you have a
No,
moment.
thanks. Heard enough on this issue. Thank you. Are the plaintiffs in a position to, by November 14th, which is a week from tomorrow, I think. Let me check. I can tell you when November 15th is because that's the beginning of the firearm deer season in Michigan. And I know where I'll be on the 15th. We will not be having any hearings that day. So the 14th is next Friday. So 8 days from now. Are the plaintiffs in a position to provide to the defense a list of 100% of the witnesses they anticipate calling and identifying the documents that you intend to offer in your case in chief?
Produce what we have identified thus far.
I'm not, thus far does not work anymore. With 60 council, with 60 days left. As far as substantive testimony, not, I'm Jim Redford. I'm the custodian of records at ABC Widget Company. ABC Widget Company keeps and maintains this in the ordinary course of business. I certainly hope that the very fine lawyers in this case are not going to be requiring the court to listen to the testimony of those folks. I mean, I'm assuming we can get business record custodians stipulated, but if not, that's fine too. We'll come. All right, so you can identify by next Friday for the defense counsel, all of your substantive witnesses, including experts, and all of the exhibits that you intend to offer, correct?
We would not want to be precluded from continuing to identify exhibits.
I can't hear her, Your Honor.
Thank you, Mr. Trudell.
We would not want to be precluded from identifying exhibits as we go through this process and possible rebuttal exhibits and so forth.
Your Honor, may I address the question from the class perspective?
Yes.
Okay. I think in large part, the answer to your question is yes. You're looking at the lawyers that have been involved in this case. We have a meeting set to start the trial discussions literally this week. So
Is that a meeting between both sides or just a meeting between the plaintiff's lawyers?
the two plaintiff groups. And so there's a little bit of hesitation there, but you've said many times, and I agree with you, we know what's coming in large
I
degree.
mean, I think
We
I could
absolutely
make
do.
all of your opening statements myself right now.
But
I
when
don't
you
know that they'd be as good as yours are going to be, but I think I could probably say what the theories are.
But when you ask the question in terms of exhibits, that's where I have a little heartburn because I've yet to meet with their trial team and actually select which email are we going to use with Luke Trumbull. So with that caveat,
All right.
With that caveat, I think we can comply with your question and we can produce the key exhibits and certainly the witnesses by that point in time.
Thank you. Anything?
Your Honor, our only request in the agenda item is to just make it a court order.
Oh, it'll be part of.
Okay, that's all. Thank you, Your Honor.
Your Honor, we would ask that it be reciprocal. There's no reason that they can't identify their witnesses.
You have the burden of proof, counsel.
I understand.
You have to go first. I mean, no, it's not going to be at the same time. I mean, that's contrary to, no, I'm sorry. And I'm sorry for being short, but no, that, you know, it's not going to be a month later, but you know, can you get it the following week?
Yes.
Okay. All right. I think it'd be best if we take a recess for 10 minutes. So court's in recess. Thank you. Time is 11:10. We're back on the record. Mr. Juan, you want to say something?
The court would allow me, Judge. I have just a suggestion. I think we can work through this process better.
Anybody with as much white hair as I have, you get to make a suggestion. So
So
that's not ageism. I'm just,
your order, I think, takes care of the concern that Mr. Gamble had about white and blue books. For instance, your order says section 1 are the admitted plaintiff exhibits, section 2 are the admitted defense exhibits, 3 are the contested plaintiff, and 4 are the contested defendant.
right. And if you
My
want to color
suggestion-
code them, that's fine with me.
Yeah, and so we're basically looking to find out whether we contest, and then we're producing our exhibits in the books anyways. What my suggestion is, Judge, is in addition to a list, if the court would give us to November 21, we will supply all of our exhibits marked and with pages on them to the defense. And then the defense can produce a book a week later with those same things. Within 2 weeks, we indicate which exhibits we object to and which exhibits we don't object to. And then the basis for the objections. And then we're there. And what it does, and it also takes care of the records custodian issue with the court, because then we know whether there's an authentication issue with the documents and whether that's an objection or not. Because that's where we're going to end up anyways, whether we're in a room together or whether we're just exchanging them this way. That's where we're going to end up. We don't agree with this one. We do agree with this one. We don't agree with this one, that kind of a process. And that's the thing that has worked the best in the past for us, because getting together for several days with 4 lawyers and 2 paralegals and clearing calendars and stuff is very difficult. And anyways, in a lot of the complicated cases that I've handled, that has worked to allow us. And if you gave us 1 more week, instead of just producing a list, we can produce the entire exhibits on a thumb drive to them, and they can look at them and tell us what they object to.
Thoughts?
Your Honor, I welcome this gesture. I think it's really helpful to move this forward. Our only request is to keep it at November 14th. I mean, we would really like to have started this already.
Mhm.
And so giving them all the way until the end of November, and then once we start it to run into winter holidays, it makes it complicated. People start disappearing. So I think that's a great idea, but it needs to start November 14th is our perspective.
And
Hold on a sec, please. I have, my wife and I are blessed with 3 great kids, 2 amazing granddaughters so far. And my son is, we have two girls and a boy, and our son, he always says to me, Dad, don't be afraid of technology. And so I'm looking, I can't even get the darn calendar to do anything other than, I finally have now expanded it, but the last 60 seconds took me to expand on my iPad a calendar where I can actually read the dates. So I'll channel my wonderful son and not be afraid of technology. All right, Mr. Juan. You've heard Mr. Gamble's statement. What's your thoughts on that?
The undertaking, Judge, to produce all of the documents that are exhibits, put exhibit stickers on them and put page numbers on them is a process that will take longer than putting together a list of those exhibits. That's why I asked for the extra week, Judge. I conferred with our team in the break and I said, can we do this? And the answer is yes. But we need that extra week in order to put all of that stuff together.
Can you get it done by the 19th, which is 2 days earlier? And the reason I'm asking about the 19th is if we did it on the 19th, as opposed to the 14th, but adding those extra 5 days gets you the actual exhibits, gets them marked, gets all that stuff. If I then give the state a week, that gives them till the 26th, which is the day before the Thanksgiving holiday. And so we don't lose that extra holiday weekend. I mean, would that?
That works, Your Honor. I'm getting nods from our team here that we can do it by then. That's only 5 extra days, but we'll get it done.
Right.
Your Honor, again, I think I appreciate that. But as Mr. Juan acknowledged, just putting a list together takes less time. It would be really helpful to us to at least have a list by November 14th.
A list of exhibits or
Yes,
witnesses?
both. Just a list of both.
Your Honor, we can certainly start, as Mr. Gamble said, he'd asked us to start earlier. We certainly can start by the 14th. And if we have the bulk of the easy ones out of the way, they can start making use of their time on the 15th, 16th, 17th, looking at those easy ones. Everybody's working efficiently. And then by the 19th, we have it complete.
All right, I understand. Yes.
I don't understand the 5-day, we want a list before we get the exhibits, Judge. We can give them a complete set of exhibits with a complete list that's final, and we don't have to say, oh yeah, by the way, we forgot to put this on the list. We forgot to put that on the list.
Well, I'm going to give you a safety valve in the order that's going to give both sides the ability to supplement, because I'm not going to say, today's the 6th of November. I'm not going to say, plaintiffs, you've been working on this case for 5 years. If you miss something on the 19th, you're done forever and for always. And I'm not going to say the same thing to the state. That just, in my mind, I don't know what the law requires. I hope I know what the law requires, but that's just basic fairness. I do not expect the Rosetta Stone of this case to be identified. Oh, we forgot to tell you about this. Then the parties can come talk to me. But so when we were on break, we were working on dates and protocols, and what I was thinking was that I'm likely to issue an order following this hearing that's going to indicate both sides are encouraged as soon as possible to exchange the name of all the witnesses they anticipate calling, and to the extent they're able to identify the exhibits they intend, just starting out with the witnesses. Here's who our intended witnesses are. If all of the lawyers in this courtroom, other than Ms. Husa and I, can't do that right now, there's trouble in Denmark, as Shakespeare said. And I'm not Shakespeare, I know that. So going to be encouraged to exchange whoever you intend to call as witnesses as soon as possible. Not later than November 19th, the plaintiffs will provide to the defense a list of the witnesses and the exhibits they intend to use. Not later than November 26th, the defense will provide the same, list of witnesses you intend to call and the exhibits you're intending to use. Not later than if a party seeks to, identifies an exhibit or a witness that listed on their first, on the submissions indicated in the paragraph above, then the defense has until December 5th to notify the plaintiffs will have until December 5th to notify defendants of the witnesses and or exhibits beyond that which was disclosed on November 19th. The defense will have until December 12th to do the same. And then there'll be language, absent extraordinary circumstances with justification articulated in a written submission to the court seeking leave to further amend. Further amendment will not be allowed prior to trial or at trial, at or prior to trial. How's that sound?
It sounds good, Judge. If we could have one other, just.
Go ahead.
No, just in terms of, we're supplying our exhibits to them. I think
Right.
we have a joint exhibit list deadline of December 12 on the case. And so what my thought process is that both sides, we've submitted our exhibits. All they have to do is tell us which ones they object to. So they end up in section 3 as opposed to which ones they agree to, which end up in section 1. But we should supply each other with our objections to the exhibits that we have and the basis for the objections by the 5th. That way we can then prepare the joint exhibit list for the 12th and say, okay, here are the ones that are
All right.
unopposed in section 1. Here are the ones for the defense that are unopposed in section 2, opposed in section 3, opposed in section 4.
Does that work?
Yes, Your Honor. That's
Okay, it sounds like it should. Okay, thank you. That's a good suggestion. Elizabeth, did you get what everybody said? I hope you're over there. This courtroom is configured. I can't see it. I hope she's nodding. Okay. Thank you all for those suggestions. And thank you. That's helpful. Very. Okay. All right. I think the floor is still yours.
That covers all the items on our agenda, Your Honor. Thank you.
Okay, defense, or gosh, plaintiffs had a supplemental that they filed on October 30th. Is there anything, did we address that yet?
There's nothing further. These issues were addressed.
Okay.
Thank you.
All right, so I want to now turn our attention to the motions. Gosh, that hurt. Great. What happened? Well, that's when Judge Redford was electrocuted. So we need a new judge, Chief Judge Godola. Sorry, I felt a little shock. Oh. Okay. Sorry. Yeah. Okay. Right now, before the court is the defense's motion to preclude evidence and testimony about the lake level. And plaintiff's motion to prohibit the defense from using it's going to take a second to get to the right page. Okay, so the plaintiffs filed on October 3rd, pardon me, a motion to bar introduction of evidence challenging. No, sorry, hold on. October 3rd, plaintiffs filed a motion to exclude the independent forensic team report and brief in support. Defendants have filed a response. So we have these two evidentiary issues. I'm not going to listen to argument now. It's not fully briefed, but I want to sort of give a global 50,000-foot view observation, having read all the pleadings thus far. First, as relates to I'll refer to, as all of you did in your submissions, the IFT, the Independent Forensic Team Report. Plaintiffs seek to exclude it. However, plaintiffs' experts have referenced it not an infinite amount of times, but a whole lot. And I am perplexed on how someone is able to testify as an expert, as I've indicated he was able to, if now we're not going to give the benefit of the fact finder being able to listen to probing exam on the underlying basis, when there's been an affirmative acknowledgement multiple times of the reference and the application of the IFT. So I'm just perplexed. I don't understand it at this point. Similarly, as relates to the lake level adjudication by the circuit court in a previous 307 case in October 2018, the defense seeks to exclude any evidence related to that, is essentially how I'm reading it. Yet, again, there are likely endorsed witnesses on behalf of the defendants who had some, either maybe an email, maybe attended, maybe talked about. I'm not clear on how that can't be examined in the fact-finding process through cross-examination, or maybe through cases in rebuttal or surrebuttal. I just don't know. So I'm not ruling on either of these, but I'm just saying I'm just, and I'm not asking for you to comment on it, but I'm saying it today because if I were a litigator and had 67 days to prepare for trial, I'd kind of want to know that, what the court might be thinking before I expended a finite universe of resources, which is the number of seconds, minutes, and hours left between now and January 12th, 2026. I'm not asking anybody to withdraw their motions. I'm not asking anybody to do anything else. I wouldn't, that would be totally inappropriate for me. And I'm not making advisory opinion. I am just seeking so that again, when this is reviewed, if they say, oh, that was definitely an abuse of discretion by Judge Redford. The reason my friends on the Court of Appeals and my very respected members of the state Supreme Court, the reason I'm saying this is to try to help motivated, capable, focused lawyers who have a whole lot to do between now and January 12th, 2026, to have the benefit of the court's thoughts. And the final aspect on the lake level issue is whether or not it was pled as in initial pleadings and as a res judicata or collateral estoppel issue. And if it wasn't, does that make it so you can't raise it now? So not ruling, not doing anything other than saying these are in crazy Jim Redford's head. These are some of the things I'm thinking about, so that we can all try to get to, Your Honor, may it please the court on January 12th, and we begin the fact-finding process in the event that in the event that the Court of Appeals doesn't stay the whole process in the meantime, in the time between now and then. And if that happens, we'll address that. But I did want to share that. I if anybody wants to if anybody wants to object to what I just said, I'll open the floor to the plaintiffs first. Any objection to those comments that the court's just made?
No, Your Honor.
Okay, any objections from defense?
No, Your Honor, just a question. I assume the court plans to hear argument on the motions?
Yeah, that's what I was wondering. I'm glad you asked that, Mr. Gamble. I would like to, but I don't want to make everybody come back. I know I'm reluctant to have a Zoom hearing on emotions of this magnitude, but I'm prepared to do it. And you've got an awful lot that you've got to get done. What are your thoughts?
Well, we have a Zoom here, or not a Zoom hearing, sorry. We have an in-person hearing scheduled already for December 5th. Were you thinking of
Oh,
hearing
okay.
argument sooner than that?
I want to tee it. I want to get it done for you guys. And then what do we have on the 5th, my friend?
Oral arguments to be heard on all pretrial motions. The current pretrial order
Sure it
already
is.
schedules
Yep,
it for
I
December 5th.
see it right there. See, my son, don't be afraid of technology, Dad. It can help once in a while. So let's hear what the plan is. Thoughts?
Number 5, we're prepared to.
If, yeah, well, December 5, we're in person, so I'm okay waiting if you all are okay.
That's fine, Your Honor.
All right, we'll look forward to the benefit of thoughtful oral argument on December 5. Okay, that makes sense. Thank you. Because I do want to give you the chance to, tell me why I'm wrong. So on both sides of the V. All right. What else do we need to cover for the plaintiffs?
Nothing further, Your Honor.
For the class, Your Honor, Jason Thompson again. And this highlights exactly my question. To a large extent, the plaintiffs on the mass side and the class side through their counsel have collaborated.
Right.
As I mentioned, we're going to be convening a trial team meeting to start talking about the witnesses in the trial. So my question to the court is, recognizing that we will continue that collaborative effect.
Mhm.
Will a lawyer from the class side and a lawyer from the mass side be able to examine a witness? Or are you ordering us to consolidate to the point that only one lawyer jointly for both the class and the mass examines a witness? And I have a suggestion if you want to hear it.
What is your suggestion?
My suggestion would be that we strive to have one lawyer examine a witness. It is a bifurcated trial. We're just doing liability at this point. A lot of the uniqueness of class isn't going to come into bear. Likewise, the defense is stipulated to the class, so we're not going to be trying the class issues and facing a motion for a directed verdict on the class. However, there undoubtedly will be some moments where we disagree amongst ourselves on how to ask a question or whether the examination was complete. And I would like to reserve the ability for one side or the other to be able to request an opportunity to follow up and examine a witness separate from the original lawyer. I don't think that's going to slow the trial down. I don't think it's unfair to the defense. And it does recognize the fact that we are not in the same case. We are a consolidated trial, consolidated cases for trial. And I don't think there's going to be many instances at all where we're going to seek to ask that leave and request that opportunity. So it will be still a very efficient trial.
Well, the defendants have multiple defendants, two different departments, as I understand. Is that right?
Yes, Your Honor.
So do they get to do that twice?
On behalf of Mass, I think we should both have an opportunity to question witnesses if they have different people questioning witnesses as well. But I do not want to waive that right now.
If they don't, so let's go to the other side of the case. Do you intend to have one lawyer for the DEQ and one for DNR and one for Mackinac Bridge Authority, or what's the, you know?
No, Your Honor, the interests of the defendants are aligned.
All
So
right.
we just need one lawyer.
All right, so they only need one. Mr. Wand, you all then just need one on your side?
Today's the first ever
In our first meeting in February 2024, what is being talked about right now is one of the reasons why the court issued advance scheduled quarterly in-person status conferences if possible. I think it's a good idea for the plaintiffs to be able to talk about this. We'll put this on let's try to get it resolved on December 5th. You know, we don't need to know today, I don't think, but I very much appreciate all the lawyers' comments and of what's next in the exam. You know, just sort of as a off the cuff, I would think that the vast majority of witnesses exams could be conducted by one counsel. There might be, and I'm gonna have to read the court rules. Boy, trial judges hate doing that. So, gosh, dang it. And maybe even the cases. What the heck?
You know them all by heart, don't you?
Nice, Mr. Juan. Yeah. Yeah. I know we're both old. I'm not, yeah, I used to know them all by heart, but now I've forgotten them. I'm so old. But no, I don't know them by heart. I look at them. I literally grabbed my in chambers set of court rules when I came up here for today's gathering. So I need to look at the court rules. When all else fails, look at the law if you're a trial judge. So anyway, I guess I'll do that anyway. So we'll talk about it on the 5th. Yeah. Okay. Anything else from plaintiffs? Any plaintiffs?
Nothing for class.
No, Your Honor.
Summerad?
No, Your Honor.
No, Your Honor.
Okay. Ms. Kennedy or Ms. Fagan, anything? Thank you. Counsel.
Nathan Gamble for the defendants, Your Honor. One question that we had just logistically, there are probably multiple witnesses that will be on both parties' witness lists.
Yep.
And I imagine, but we wanted obviously to speak to the court about it, that let's say the plaintiffs call this witness, they direct and we cross-examine, but if that's a witness we also want to examine, will we then be able to direct and then they can cross? And my point is, rather than witnesses, just have them sit once rather than have to come back
Okay.
a week later or 2 weeks later.
Yeah. And again, I suspect you're right on that. Mr. Juan, you're grabbing the microphone like you're ready for karaoke night. Okay. What's up?
My comment, when you run these trials, usually they have the right to recall a witness in their case if they want to. From an efficiency standpoint, I think it's best if we complete all the stuff with the witness when they're here, but that's
Right.
their prerogative.
Yeah, I agree that that's what, all of us who have done trials have seen witnesses called by both parties as their own witness. I've done it both ways, both as a litigator and as a trial judge. And I think the goal, especially for out of town witnesses who've traveled, will be in January, maybe February, hopefully just January, winter in Michigan. So if we can get a witness, if we spend another hour with a witness and we're able to let that witness return to their home state or whatever, that's certainly my preference. Same thing for experts. If we're getting to the end of a trial day and if we can take an hour or 90 minutes of testimony and we go until 6 or 7 o'clock, but that means that whoever retained the expert gets to, they can leave that night and save their clients $1,500. I'm all for that. We will not be doing what I did in the Navy, driving out of the port, going to the ship and beginning the trial at 11 p.m. and going until 3 in the morning. We won't be doing that. But, you know, I'm willing to try to be reasonable. And I guess when I think that's something we can talk about on the 5th. But as far as just general purposes, if you want to not recall them and go into your direct, I'm okay with that. I guess the one proviso for plaintiffs, you would have to, do we want to, if we do that, excuse me, will the plaintiffs agree that by conducting that manner of examination of the witness, the defendants would not then be waiving their right to make a motion at the close of the plaintiff's proofs for a directed verdict? Because I would suspect, I know every case I ever defended, I always made it, and so I don't know what your thoughts are on that. Okay, yeah, so long as there's this prophylactic. Yep, Mr. Thompson.
This just highlights my point. We don't agree. So I wanted to just pipe in and say that is the plaintiff with the burden of proof. I recognize it's a bench trial. It's not
Right.
necessarily same as a jury trial, but I don't want to be interrupted with my case. And I also don't want to be preparing another cross when I'm already trying to try my case. And Chief, as you mentioned, we are the plaintiff. We have the
Okay, all
burden.
right, so then let's do this. Let's just talk about it on the 5th. You make your decisions. And then when we're at trial, and again, sort of along the lines of, what I talked about previously when I told you what some of my thoughts were about other issues, Mr. Thompson, you might as well be on notice that if we've got somebody from Arizona who's a witness and has a, and you're in the second day of testimony, and we can make it so this witness from Arizona doesn't have to come back 3 weeks from now or 2 weeks from now, I'm going to probably be overruling your objection, memorializing for the record and everything else, and we're going to go take the proofs. So I get it, understand, just so we're all, I don't want, the one thing as a trial lawyer I did not like was surprises. And so I don't want you to be surprised that I say, yep, I know you said that, Thompson, but we're moving forward. And then you say, no, you should have told me before. Well, I'm telling you now. So
I'm nodding my head. Yes. In a situation like that, you're not going to get an objection from me, but if
So-
it's someone's local.
yeah. So, I mean, it's all relative. That actually does make me think of one thing I've been thinking about. That'll look great on the record. As a military judge, you had to certify the transcript. And so every trial I had as a military judge, I had to read the entire transcript before it could go to the next level of review. And it's so embarrassing to read what you actually say as a trial. Yeah, it's like, oh my gosh, did I really say that? So I'm visualizing myself reading what I just said. Anyway, I digress needlessly. January in Michigan, January in West Michigan. Very snowy sometimes. Sometimes it's dry and clear and spectacularly beautiful, but cool. I'm not directing anybody to do anything as far as hotel accommodations, but I would strongly urge counsel to have, if you do not reside, I would not, the longest trial I ever had was 8 weeks long. It was in Lansing. It started the first week in November. It ended the middle of December. I got a hotel room, even though it's only 60 miles away, and I stayed in a hotel in Lansing every night that the jury was going to be there the next day. So I'm not telling anybody to do that, but I can tell you from in my life experience, that's what I had to do. And even when I tried cases in Kalamazoo in front of Judge Enslin, in the winter, I would get a hotel. It just, And then all you got to do is walk through the snow. It's just so much easier. I live 5.2 miles away from here. I can walk in if I need to when we're in trial. I hope not to because I got a 4-wheel drive truck and a pretty good snow blower to clear the driveway. But in all seriousness, anticipate the anticipatable, which is weather which will make it not possible for you to get here in time for us to start at 8:30, which means probably want to think about hotel accommodations. But again, that's for you to decide and your team to decide, but that would be my suggestion. And Grand Rapids is a lovely town. It's been our home for 35 years. There are a lot of great hotels and restaurants. And you save 2 hours of trial prep time in the windshield every day if you can do it. So, but it's up to you all, obviously. Gosh, how did I not realize that might be as a former government employee? The court said I got to get a hotel room. Yeah. So yeah, I'm not ordering anybody to get a hotel room, but I strongly suggest it as just for your own safety, and being able to really be ready. You know, it's just, you're welcome. All right. Anything else?
Nothing for Clyde.
Nothing further, Your Honor.
Nothing for us, Your Honor.
All right. I appreciate so much, and I'm so honored to have the privilege of serving on this case with each of you, for your clients' respective claims and defenses. It's an important matter for everyone. And I appreciate everybody doing everything they can to help me get to a point where I make the decision that I'll have to make. Assuming the Court of Appeals doesn't adjourn the case for us. Been good to see everyone. I hope everyone has a pleasant November and Thanksgiving. Court is in recess. It is 11:46. Thank you. Have a good day.
Thank you.
All right. Appreciate everybody. Thanks, Mr. Trudell. Appreciate you.
Thank you.
You sure you don't want to come over here to be the court reporter in person for the trial?
That depends.
Kick it around, my friend. Kick it around.
All right, thank you.
What's the stake of the paper? It's hotel room.
I know, that's the problem.